Let me start with a hard truth, one that every responsible gun owner needs to engrave in their mind. Surviving the gunfight is only half the battle. The real fight often begins when the sirens are wailing and the red and blue lights paint the scene. In those moments, you're no longer just a citizen. You are the central figure in a major criminal investigation. Your future, your freedom, and your family's stability hinge on the decisions you make in the minutes, hours, and days that follow. I've spent countless hours speaking with criminal defense attorneys, use of force experts, and even former police officers who now consult for the defense. The message is unanimous and chilling. The legal system is a machine built to process crimes. In the chaotic wake of a defensive shooting, that machine can easily mistake a justified act of self-preservation for a criminal homicide. Your words and actions are the raw material it will use to build its case, for or against you. This isn't a guide on how to get away with it. This is a guide on how to navigate the most perilous situation of your life without accidentally destroying your own legal defense. We'll walk through every phase, from the echo of the final shot to the long road of legal proceedings, grounding everything in the reality of U.S. law. Part 1. The mindset before the unthinkable happens. You cannot prepare for a crisis in the midst of crisis. The foundation for surviving the legal aftermath is laid today, years or decades before you ever face a threat. 1.1 Understand the psychological aftermath, the triune of trauma. In a lethal confrontation, your brain operates on a different level. You experience tachypsychia, the distortion of time. Events may seem to happen in slow motion or blinding speed. Tunnel vision. Your peripheral vision collapses, focusing only on the threat. Auditory exclusion. Sounds become muffled or disappear. You may not hear your own shots. Memory fragmentation. Your brain does not record events like a video camera. It grabs sensory snapshots, the glint of the weapon, the feel of the grip, the expression on the assailant's face. These memories are stored out of sequence and are highly malleable. Why does this matter legally? Because when a detective asks you, how many shots did you fire? Or what exactly did he say before you shot? Your brain may not have an accurate answer. If you guess 3 and forensics finds 4 shell casings, your credibility is shattered. Your honest, trauma-induced memory lapse becomes a lie in the case file. 1.2 The Pre-Event Legal Preparedness Checklist. Attorney on speed dial. Your phone should have the contact information for a qualified criminal defense attorney who specializes in self-defense law. Not your uncle's divorce lawyer. A specialist. Research them now. Many offer prepaid legal services or are available on retainer. Insurance. Consider concealed carry insurance or a legal defense membership. Understand exactly what it covers. Criminal defense, civil liability, bail bonds. Read the fine print. Know their 24/7 emergency hotline number. Knowledge of local law. Self-defense law varies wildly by state. Do you live in a stand-your-ground state or a duty to retreat jurisdiction? What is the legal definition of grave bodily harm or reasonable fear in your area? Ignorance of the law is not a defense. Family briefing. Does your spouse or a trusted family member know the plan? They need to know 2 things. 1, your attorney's name and number. 2, to say nothing to anyone if you are involved in an incident. Well-meaning family members can inadvertently provide devastating statements. Part 2, the immediate aftermath, the first 60 seconds to 60 minutes. The threat is down. The air smells of sulfur and copper. Your heart is trying to escape your chest. This is where the legal battle is won or lost. Step 1, secure the scene and your safety. Scan. Your tunnel vision needs to widen. Are there other threats? Accomplices? Bystanders? Secure your firearm. If the immediate area is safe, holster your weapon. If not, safely place it on the ground in a visible location away from the downed assailant. The goal is to not be holding a weapon when police arrive. Render aid? This is a complex moral and legal question. Your legal duty is generally to yourself first. If you render aid, you risk contaminating the scene, and your actions could be misconstrued. The safest legal position is to call for professional medical aid immediately, but to not approach the assailant unless you have specific medical training and can do so safely from other threats. Many attorneys advise against it, as kneeling over the person you just shot is a problematic image for a jury. Step 2. The 911 call, your first piece of formal evidence. This call is being recorded and will be played in a courtroom. Your tone, your words are critical. State your location clearly. I'm at 123 Main Street, apartment 4B. Identify the emergency. I need police and an ambulance immediately. Identify yourself as the victim/reporting party. There has been a shooting. I was attacked. Use the passive voice to frame the event. Describe the threat. The person who attacked me is on the ground/description. He had a weapon. Be factual. Describe yourself. I'm a caller. I am the one with the firearm. I am wearing description. I will comply with officers when they arrive. Follow dispatcher instructions. Do not hang up until told to do so. What not to say on a 911 call. I just shot someone. Sounds like an admission of action, not reaction. I killed him. You don't know that, and it's inflammatory. Any details about the number of shots, why you were there, or past history. Anything argumentative or emotional. Stick to dry, factual reporting. Step 3. Police arrival, the high-risk interface. When you hear the sirens, your hands go up, palms open and visible. You are now in the most dangerous part of the process. Officers are arriving at a man with a gun call. Their priority is not your story. It is to control a lethal threat, which at this moment includes you. Comply with every command. Show me your hands. Get on your knees. Interlace your fingers. Do it slowly, deliberately, and verbally confirm. Okay, my hands are up. I'm getting on my knees now. Do not make sudden moves. Do not reach for your wallet, your phone, or to holster your weapon unless explicitly commanded to do so. Expect to be handcuffed. You will almost certainly be detained, searched, and placed in handcuffs. This is not an arrest, yet. It is a tactical detention to secure the scene. Do not resist. Do not take it personally. It is a universal procedure. Step 4. The critical exchange, invoking your rights. Once you are secured and the scene is under control, an officer will begin questioning you. They may seem calm, even sympathetic. This is the moment that defines your legal future. You must deliver your 4-part statement clearly and calmly. Officer, that person attacked me. I was in fear for my life/my family's life. This establishes the core of your self-defense claim. I will sign the complaint against that person. This formally positions you as the victim seeking justice. I am invoking my right to remain silent under the Fifth Amendment, the formal, legal trigger for your constitutional protection. I will not answer any questions without my attorney present. This ends the interrogation. Period. Then you shut your mouth. Do not elaborate. Do not answer clarifying questions like, "Can you just tell me what happened?" Or "Where did he attack you?" A simple, polite, "I've invoked my right to remain silent, sir. I need my attorney," is your only response. Why this is non-negotiable. Your memory is fragmented. You are in shock. Your statement will be full of gaps and inconsistencies. A skilled investigator can use these inconsistencies to suggest you are lying or that your story is evolving. By remaining silent, you deprive the state of its most powerful piece of initial evidence, your own confused, self-incriminating statement. Step 5. On-scene evidence and statements. Do not consent to searches. If asked for your phone password, to search your car, or to enter your home without a warrant, your answer is, "I do not consent to any searches." Say it respectfully. This protects your Fourth Amendment rights. Do not make excited utterances. Even after invoking your rights, you might be tempted to blurt something out to a different officer or EMT. Treat every person at the scene as a microphone recording for the prosecution. Silence is your shield. Identify witnesses if safe. If you can, and without breaking your posture of silence, you might simply point out to an officer, "That woman in the red shirt saw the whole thing." Direct them to evidence and independent witnesses without giving your narrative. Part 3. The investigation from the street to the interrogation room. You're now in the system. The process is methodical and stacked against the unprepared. Phase 3A. Detention and transportation. You will be taken to a police station. You are still likely detained, not under arrest. Continue your silence. Ask for your attorney repeatedly. Do not make small talk with the transporting officer. Anything you say is admissible. The classic, "I've never done anything like this before," or "I can't believe this is happening," can be twisted to imply doubt or guilt. Phase 3B. The interrogation and the read technique. You will be placed in an interview room. Detectives will enter. They are professionals whose sole goal is to obtain a confession or a statement. They are allowed to lie to you. They may employ the read technique. Building rapport. We're here to get your side of the story. We just want to understand. Theme development. They will present a narrative that minimizes your culpability to get you to talk. "Look, we get it. He scared you. You didn't mean for it to go this far. Maybe you just meant to scare him and the gun went off." Overcoming objections. If you say you're innocent, they might say, "Innocent people always want to talk to clear their name." Alternative question. They will give you two choices, both implying guilt. Did you plan this out? Or did it just happen in the heat of the moment? A heat of the moment confession is still a confession to a crime, like manslaughter. Your only defense against this is your absolute, unwavering silence and your demand for an attorney. The moment you say, "I want a lawyer," all questioning must cease. The Supreme Court has ruled this. Edwards versus Arizona. Write it on your hand if you have to. Lawyer. Silent. Phase 3C. The arrest decision. Based on the initial evidence, the police will decide to either release you or book you into jail. Do not be shocked or despondent if you are arrested. In a homicide, justified or not, arrest is common. Your attorney will work on bail. Part 4. Working with your attorney, building your defense. When your attorney arrives, you can finally talk. Tell them everything. Attorney-client privilege is sacred. Hold nothing back. The good, the bad, the embarrassing. They need to know the full truth to build the best defense. What your attorney will do. Secure your release. Argue for your release on your own recognizance or negotiate bail. Investigate. They will hire a private investigator to visit the scene, interview witnesses who may have dispersed before police arrived, photograph evidence, and reconstruct events. Manage evidence. They will obtain 911 calls, police reports, forensic reports, ballistics, autopsy, and any surveillance footage. Navigate the prosecution. They will communicate with the district attorney's office, often working to present your case proactively to prevent charges from ever being filed. This is where your early silence pays dividends. There is no contradictory statement for the DEA to latch onto. The decision to charge. The DA will decide whether to file criminal charges. They look at the evidence through the lens of, can we get a conviction? A clean, legally justified shooting with a cooperative but silent defendant who has a strong legal team is a very difficult case for them to pursue. Part 5. The long haul, civil liability, and personal recovery. Even if criminal charges are never filed, your journey is not over. 5.1 The civil lawsuit. The assailant or their family can sue you for civil damages, wrongful death, negligence. The standard of proof here is lower, preponderance of the evidence versus beyond a reasonable doubt. This is where legal defense insurance is crucial. Your criminal attorney may not handle civil cases. Be prepared for this possibility. 5.2 Psychological recovery. You have taken a life to save your own. This carries a profound psychological burden, known as moral injury or post-traumatic stress. Seek professional help from a therapist experienced in trauma. This is not a sign of weakness. It is a necessary step in healing. Your mental health records are generally protected and are vital for your own well-being. 5.3 The court of public opinion. In the age of social media, your case may become public. Do not post about it. Do not comment. Do not give interviews. Let your attorney handle all public statements. Anything you say can be used in both criminal and civil proceedings. Conclusion. The burden of the armed citizen. Carrying a firearm for self-defense is the acceptance of a tremendous responsibility. Not just the ethical responsibility to preserve life, but the legal responsibility to navigate the most complex and perilous aftermath imaginable. The gun is the simplest part of the equation. The true test is played out in interrogation rooms and courtrooms. Your rights are your tools. The Fifth Amendment right to remain silent is the most powerful tool in your post-event toolbox. Using it is not guilt. It is wisdom. It is the conscious choice to let the facts, the forensic evidence, the witness statements, the scene itself, tell the story rather than your traumatized and vulnerable memory. Prepare your mind now. Have a number. Know the words. Hope with all your heart you never need them, but be steeled in the knowledge of what to do if that day ever comes. Your life, in every sense, depends on it. A question for reflection. We spend hundreds of hours and dollars on range time, gear, and shooting drills to master the physical act of self-defense. Yet, the legal and psychological aftermath is often an afterthought. Do you believe that dedicating equal time to studying use of force law, practicing post-incident scenarios, and mental preparation is a necessary part of being a truly responsible armed citizen? Why or why not? I'd be genuinely interested to hear your perspective in the comments below.